Parents often disagree about social media use with respect to their children. Now, in divorces, they disagree about a lot of things, but what happens when the parents disagree on this? You think that it's an 8-year-old child, nothing wrong with them having unfettered use of the iPhone. Your ex doesn't see it that way. What are the courts going to see it as? How are the courts going to look at it? Well, number one, and it's kind of an obvious answer, the courts are going to look for safety first. To the degree that social media use exposes your child to risk, the court's not going to like that. So if your child is doing something that's potentially out there, it's putting something out there which could expose them to risk, the court is going to blame you for that risk. So you're going to watch out for that. Now, a second thing you want to look at is the court might evaluate screen time versus school issues. If you're letting your kid have unfettered use of the iPhone and at the same time they're bombing out on their tests and their school grades are suffering, the court's going to say, you know what, you're indulging this habit to the expense of scholastics. Court is not going to like that. The court will consider the maturity of the child too, though. I mean, obviously, if the child is mature enough to use the phone in a healthy way, but at the same time stay off the computer when they have finals, the court will say, okay, no problem. The court will consider the maturity of the child. You have to understand one thing. The court may very well order consistent use in both homes. It shouldn't be the case that in one house, the child has, carte blanche, and in the other house, there's police rules. So you've got to watch that. The court would really, really like the parents to figure that out on their own, to really come up with and communicate expectations so that there will be uniform rules. But if you can't, bear in mind that the court has the discretion to say, okay, in both houses, no more than 45 minutes a day on the cell phone, no more than an hour of Minecraft. The court can do that. And if the court does that, it's going to apply equally across the board to both homes. So the court could very well fashion an order like that. So knowing that, it's better, instead of having the judge say, you shall do this and you shall do that, it's better for the parents to get together, collaborate on a plan that makes sense for both so that there will be equal expectations across the board in both households.
248-588